How are you?
I don't know.
I'm looking for every great recommendation I can receive from you today, sir. I have been in a very horrible assaultive position
Okay, let me
since I left your
hold on a second.
okay.
State your name for the record.
Danette Mellick.
Okay, go ahead, Miss Mel.
Well, I entered your courtroom honorably last year at this time. I came in as a plaintiff.
The hearing opened with defendant Danette Mellick immediately launching into a long and confusing explanation about property management, alleged broken promises, and courtroom agreements. The judge repeatedly tried to understand the actual legal issue before the court, but the defendant kept drifting into unrelated accusations and emotional complaints. From the very beginning, tension filled the courtroom as the judge struggled to keep the discussion focused on the eviction case itself.
Okay.
And when I swore in, I gave some information about one company, Akram Rashid, merging with a new owner. At that time, I, the customer, was not given the respect, nor any other tenant in my building, underneath the laws to meet this person as a consumer. It is of complete responsibility for a new company to acquire the permission of the tenant, where money is concerned, to enter a good consumer relationship. This did not happen. Time proceeded, and this maintenance company decided to enter person's property with no permission, started to manipulate them, stealing possessions, stealing automobiles.
Hey, ma'am, can I ask you something?
Sure.
Is this your motion to set aside the judgment?
Well, I did set it aside, and we met that agreement. An attorney named Kevin Callahan sat in a court with me as a plaintiff. According to the law, there are no attorneys allowed. So I tried to motion in at the end of August because I recognized.
Hold on. No attorneys allowed where?
When I first met with you, Your Honor, I went into a small claims, and I was underneath the impression through the courses of the law that there were no attorneys allowed in a small claim. So something kind of got jangled up. I presented charges.
Ma'am, hold on.
Okay.
Okay, because I want to make sure.
Mellick began speaking in a way often associated with sovereign citizen arguments, insisting that attorneys were not allowed in small claims court and suggesting that agreements made under oath overrode the legal eviction process. She repeatedly referred to verbal promises, consumer rights, and alleged misconduct instead of addressing why she missed court hearings. The judge quickly realized the hearing was heading off track.
That I've got everything in front of me. Was there a small claims case?
Yes. And at that time, we made an agreement.
Go ahead.
That after August, which was Akram Rashid's current lease, that there were not supposed to be any changes to, yet that wasn't the case. I would be on a month to month. I raised my right hand. Kevin Callahan, yourself, and I made that agreement. He swore to me, my mother, which then reported it to my banks. I reported it to my private attorneys in New York City that managed my work. And I contacted the courts. I talked to him verbally over the phone from his office in St. Clair Shores. And he stated to me that I swear, you're going to receive that sheet of paper. I waited and I waited and I waited. Spring and summer came to fruition, and I called the courts. It's getting, later in the year. Where's the sheet of paper? It was as easy as that. There was no failure of me to make the payment. I still have the finances set aside. I feel like they are trying to retaliate against me because I've continued to make reports, which is my sole discretion. I have the right to do that. between the Michigan State Police that were called on numerous occasions by other
Ma'am, I'm gonna have to stop you because I'm not clear what you're talking.
Well, I think that there's a position here where there's charges that he wanted to dismiss, but because he did not fulfill the obligation that he promised me, by August, I was being manipulated and they're not following through with their original
Manipulated
agreement.
by whom?
I, yourself, and Callahan last January coming into February. We sat in the Zoom conference. I presented the paperwork that was unorthodox. of
Judge, if I
one
may,
owner
I
and
have
another
information
owner.
on this. I can.
And this change of ownership will not affect your lease agreement. She put unless.
As the defendant continued talking over the court, the judge interrupted several times, trying to narrow the issue down to one simple question: whether there was any legal basis to set aside the eviction judgment. Instead of answering directly, Melick returned to stories about management companies, missing paperwork, and verbal agreements. The judge's patience visibly started wearing thin.
Otherwise indicated in your current signed lease. Well, unless otherwise means I can't do what I'm claiming I'm going to do. She broke these laws.
She being whom?
E.J. Elizabeth Jefferson, who claimed to be a property manager that no one had ever met. There is no legible address. The Attorney General states that she's not a registered or licensed person. The federal offices told me not to be in business with them.
Ma'am.
Yep.
I'm going to tell you right now, you've lost me.
Well, from the very beginning, I presented, the first time I came in to see you, I presented both pieces of paper.
Stop for a moment.
Okay.
I had them pull a small claims case involving yourself against Bell Management.
Yeah, they did things that were illegal. Fair housing.
Ma'am, that was over a year ago. I would like to say I absolutely remember that.
Yeah.
But I don't.
I'm in dismay myself, sir, because I made that agreement with you. I clearly don't allow a judge or myself to be taken advantage of by an attorney's office.
Well, I don't know that I've been taken advantage of.
I believe I have been.
Okay.
I would not enter your courts to present this witness information as
Ma'am, stop for one moment. Okay. Let me hear, I've heard from you for a while. Let me hear from the other side.
Okay.
Mr. Callahan.
Thank you, Judge. Kevin Callahan, P78273, representing Bell Asset Management. The matter that Ms. Melick is speaking of was a previous matter, a small claims matter that was filed against my client in conjunction with a non-payment of rent matter that we filed against Ms. Melick. Those matters have been decided. Those matters are closed. It has no bearing on this matter whatsoever. This current case, Ms. Melick even admitted she's on a month-to-month tenancy. We provided a 30-day notice to Ms. Melick. She never showed up to court, so a default judgment was entered back in October against Ms. Melick. We subsequently filed a writ of eviction. That writ was signed by Your Honor.
Melick insisted that opposing counsel in the court had promised her a month-to-month lease agreement after August. According to her, she relied entirely on that promise and believed everything would be resolved once written confirmation arrived. She claimed she repeatedly contacted the attorney's office asking for paperwork, but never received it, leaving her confused about her legal standing.
And now we get this motion to set aside that default 2 months after the default was entered, alleging that no attorney present and it was against her rights. And I'm as lost as you are with this, Judge. There's no basis to set this judgment aside. Ms. Melick is a month-to-month tenant. She has to vacate the property. However, I will say for the record, because I'm not going to let my reputation possibly be besmirched on the record here of doing anything illegal or improper, Ms. Melick has called my office and left over 120 voicemails accusing me of crimes under the federal law that don't exist, made threats against me, my family. Ms. Melick, I allowed you to speak. Please allow me to speak. She's made threats against my bar license. She's made threats against my family. She's made threats against my office staff. It has been deplorable what my staff has gone through with Miss Melick over a situation that is a simple month-to-month termination, and Miss Melick refuses to leave the property, Judge. We're just asking for that judgment to stand and the writ to stand so that my client can move forward.
Leave the property. I never made any threats to anybody's family. I never made any threats to anybody. I did call the office. I asked him for the sheet of paper that he promised. He said he would give me a month to month after August. I said, what is going on? I said, give me the oral confirmation or the written confirmation, and I'm going to continue to pay the money from August onward. I asked your court, I said, may I please have the sheet of paper?
Ma'am.
I did not threaten anybody.
Okay, fine. I don't know anything about that. And I'm not.
If he made an agreement about a month to
ma'am,
month, why am I?
Ma'am, you have interrupted me numerous times.
I'm sorry.
That needs to stop.
I did not threaten anybody.
Okay,
Okay.
fine. Always
Just
two sides to
deplorably
the story.
Rude.
But the reality here is you're before the court challenging, you're asking me to set aside a judgment to stay the writ.
She then told me, she flip-flopped with me 3 times.
Every time the judge attempted to speak or clarify the law, the defendant interrupted with additional accusations and explanations. The court warned her multiple times to stop talking over the judge, but she continued doing it anyway. What started as a routine eviction hearing slowly transformed into a courtroom struggle for basic order and control.
She put another sheet of paper underneath my door asking me, E.J. Jefferson. She
Ma'am,
asked
that has
me if I
nothing.
abandoned my unit.
Ma'am.
Then she tried to take the money out
Ma'am,
3
okay,
times
ma'am,
in
I'm gonna,
September
you know
and
what I'm gonna do,
October.
ma'am? Here's what I'm gonna do.
But there was no order.
Ma'am, I'm
She-
gonna pass
She
the matter.
asked me to move
Quit
out.
interrupting me.
Yeah, she's still
Quit
trying to take the money.
interrupting me. That's warning 2. On the third one, I act. You're before the court to set aside the judgment and the writ.
Yes.
So that the record is clear, the judgment was entered for failure to appear at 2 hearings. First one being October 6th, and then on October 20th. I issued of 2023. I issued the judgment.
Because I thought that the month to month would be honored. That's all. That's all that he gave me. It was all the information I went by, was what I was sworn in. When I'm underneath oath, an agreement is made, nothing happened other than me calling his office and asking for that sheet of paper. I diligently, respectfully, and responsibly,
Ma'am, you can have a seat before I find you in contempt. That is now the 3rd time that you have interrupted. Have a seat. Okay. Got one more. We'll call this back. Court recalls the case Bell Asset Management versus Melee.
And for the record, Judge, again, Kevin Callahan for plaintiff, P78273.
Attorney Kevin Callahan finally addressed the court and completely dismantled the defendant's narrative. He explained that prior small claims matters had already been resolved and had nothing to do with the current eviction case. He also confirmed that Melick failed to appear at multiple hearings, resulting in a lawful default judgment and properly issued writ of eviction.
State your name again, Miss Melick.
Danette Melick.
All right. Let me, before anybody else says anything, because this is going way far afield. The only issue before me is the order that I issued in October, which was the judgment, and then the writ of eviction.
Well, I failed the October. I don't know how. I got confused. I'm not accustomed to the courts.
Ma'am, but if at any given time, here's what the problem for you, Miss Ma'am, and I'm just going to be blunt about it. That judgment went out from the court shortly after my signing. All right.
Sir, may I ask something of you? Once an agreement is made in court, isn't that you respectfully gave me the month to month. He told me if I drop the charges on his group, his client would agree to give me a month to month. I mean,
Then you're going to have to file a new claim that alleges that. That's not before me.
That's why I motioned in August.
No, but that is not before me today.
This is how I will state it.
No,
No, wait.
you won't.
That's
not before me.
I can pay the money. There was never a failure. I swear, I had the money aside.
They want you out.
I
It's
didn't.
not about the money.
They asked me to pay. There was no probable cause in any level. I called his office respectfully. I asked him for the sheet of paper for the month to month that was agreed upon after August. She put a renewal underneath my door. If she wanted me to leave, why was she sending me a renewal? She tried to take the money out in September and October. That would mean I'm still on a month to month.
The courtroom atmosphere changed instantly when the attorney revealed that Melik allegedly left over 120 voicemails accusing him of fake federal crimes and making threats toward his office and family. The judge immediately stopped the interruptions and allowed the attorney to finish uninterrupted. The accusation stunned the courtroom and seriously damaged the defendant's credibility.
I just said, where is the paperwork to confirm that? My bank has it on the record, JP Morgan Chase, September and October.
Ma'am, they want you out.
But she asked me to renew.
Ma'am, I don't know about any of those conversations. They have properly been granted a judgment for possession. They properly filed the writ or the order of eviction. I've signed the order of eviction. There is no basis, and I've listened to everything you said to me. There is no basis for this court to set aside that judgment or to stay the execution of the order of eviction or the writ of restitution. There's no legal basis for me.
I can't pay the money that was agreed upon.
They don't want the money.
Even though she tried to take it out in September and October.
This is a termination of tenancy case. I don't know anything that they've done regarding taking it out. This is
They did. They
termination.
tried to take the money out.
Okay, ma'am, that's fine. I don't know that. But even if that were true, the judgment in this case.
I have not done anything though, Your Honor. I mean, this is against the law.
No, what would be against the law is me to grant your relief you're requesting because
Melik quickly denied making threats and insisted she only wanted the promised paperwork confirming her tenancy status. She claimed she was confused because management allegedly attempted to withdraw rent payments while simultaneously trying to evict her. Despite her emotional defense, the judge repeatedly reminded her that none of those side disputes changed the legality of the eviction judgment.
Like you have rights, they have rights. You brought this before the court. And I'm going to say it again to you, so hopefully it'll sink in. They properly got a judgment. Upon properly getting that judgment, they properly requested an order of eviction. I issued the order of eviction. That order of eviction, the judgment, because you have not provided a basis that will stand. Your motion.
I did nothing after August other than oblige where a month to month was concerned. That was the agreement. I did not refuse payment. There was no probable cause. She put a renewal underneath my door. I says, well, where's the sheet of paper if you're trying to renew? And then she's flip-flopping back and forth with me. Well, I'm like, okay, I thought I was supposed to be on a month to month. That's all it was. She lied to me. And then she lied to me again. And then she tried to take the money out 3 times. So it got me confused. I'm like, well, then am I on a month to month? The bank has that on record. So it came.
As the defendant continued interrupting proceedings, the judge issued direct warnings and threatened contempt of court. Even after being told several times to stop speaking over others, Mellick continued arguing every ruling and explanation. The judge finally ordered her to sit down after declaring that her constant interruptions had crossed the line.
In thinking that if I spoke the truth, because I was sworn in last year and it was agreed upon that I'd be on a month to month after August. That was it. It was as simple as that. I contacted your courts on numerous occasions prior to the end of August.
Ma'am, maybe you don't understand. I just issued my ruling. Your motion is denied. What I will indicate is that the escrow will be held for 15 days and then it will be released back to the defendant. I will not pay the escrow over to the plaintiff. It will be released back to the defendant in this case. Thank you.
So what is the
Thank you,
time
Judge.
frame to, may I have till the end of January, sir?
Ma'am, you're operating on borrowed time. I signed the writ
I cannot just,
December 3rd. I signed the writ December 3rd.
to have a moving truck in, please, sir. I mean, it is the dead of winter. I have no problem moving out. I've been looking for another place because I don't trust the people. First, they're making an agreement with me and then they're flip-flopping. Could you please, a little courtesy where this is concerned, please?
You've not granted me any courtesy in terms of your talking. Why should I grant you any? But despite that, the writ will not execute prior to January 16th. So I will give you that grace of 10 days, and if I hear anything else, I may take that.
So I have to be out of this place by January 16th?
They cannot execute the writ prior to that date
Okay,
because otherwise they could do it tomorrow.
right.
I am giving that 10-day, I'm giving you that period. I'm not giving you to the end of the month. I'm giving you that period. That's as far as I'm going. I'm done.
I don't know what I did and I feel swindled.
Judge, should I enter a order to that effect or will the court? produce
Yes,
the
sir.
order?
Please.
Okay, thank you. I will
Prepare an
email.
order under the 7-day rule, please.
I'll do that.
Thank
Thank you,
you.
Judge. Have a great day.
You do the same, but too late.
The escrow itself, when does that get repaid to me?
You need to listen to what I just told you. 15 days, I will release the escrow back.
May I enter a bank account number or an
No.
address to you?
No,
I have to give you a different address because if I'm not going to be living here,
ma'am, you can give it to the clerk's office.
The judge carefully explained that the only matter before the court was whether there was a valid legal reason to overturn the previous eviction judgment. Personal beliefs, verbal side agreements, or complaints about management behavior were not enough to undo a lawful court order. Since she misscheduled hearings and failed to provide legal grounds, the judgment remained valid.
Good afternoon, good evening,
Good night.
Happy New Year. Something.
Okay,
How
what
are
is
you
your
today?
name?
My name is Trudy Avey.
Okay, and who do I have here?
Donald McMahon, man.
Okay, you need to take your hands out of your pockets, please. And you?
Maureen, yes.
Okay. So folks, where are we on this case?
I am the landlord, and in October, I had served with everybody raises on their rent. And they had notified me they weren't going to be able to. And I had done the paperwork, served with a notice to leave. And then we made an agreement. I went along with his agreement and he we decided, I gave him everything he wanted, everything he asked for. And we signed it legally. I gave him his money and paid, then he tried to pay me for December to stay and he was supposed to be gone December 1st. And December 1st, I had new tenants starting to move in. And now they can't. And now he's still staying there. He still will not leave. So I filed again to see you. Does he want to leave the premises? And I don't.
All right.
The place where we're moving to, we had setbacks because they were doing improvements. They were doing upgrades. And it was supposed to be done last month. And the upgrades are going to be done this month. You have a lot of tools and it's a business to move out of there. So we have to have a place to go in order to move everything. It's, you know, and our original rent, the lease agreement is right here.
You
And
have the
then,
original copy. Excuse me.
Her doctored version is this one here. So our lease agreement, she stated when we asked her about this.
After hearing the judge repeatedly say, "They want you out," the defendant slowly realized the case was no longer about unpaid rent or confusion over paperwork. The landlord simply wanted possession of the property, and the law allowed them to pursue eviction. No amount of emotional explanation could reverse the completed legal process.
And the way she spelled it out, she said we could stay there as long as we wanted. Okay, I did a bunch of plumbing work for this unit in order for it to be even rented. I got pictures of that. I got receipts for everything. We carried her for a year. And
Oh, hold on a moment, folks. But right now, there is no lease agreement.
There is no
Okay, but
lease.
listen to my question, people. There is no lease agreement right now. Okay, so now my question becomes this. Okay. You thought they were going to be out at a certain point. They're not out.
December 1st was, we agreed on it. We probably
Okay,
signed all the, yeah.
that's, why does everybody want to expand on my question?
I apologize. I'm tired. It's been a long day.
Tell me about it. And you had a tenant ready to move in. They didn't move in because okay.
I'm sorry, Your Honor. Go ahead. I'll shut up.
Okay. So is that tenant now lost? They're not there, right?
Waiting.
They're waiting. Okay. The unit you guys were going to move, but the place you're moving into needs to have work done on it so you can move into the unit.
yes, sir, they're upgrades and they're just finishing.
Okay, I heard you the first time. All right, I get it. When people tell me if I don't hear something, I'll ask. So when will the upgrades be done?
It'll be done this month.
So if the upgrades are done, what day can you be out?
By the end of this month.
Okay. Now, Miss Avey, will the tenants that are going to move in, can they wait till February 1st to move?
They have been waiting 3 months now,
I
and I'm
didn't ask
afraid
you
I'm
that.
gonna lose them.
I didn't ask you that. Can they wait or can they not?
They cannot wait.
Okay, have they told you that?
Yes, because they planned on December 1st.
The court officially denied Mellick's motion to set aside the eviction judgment and refused to stop enforcement of the writ. The judge emphasized that granting her request would actually violate the law because the landlord had properly followed every required legal procedure. It became clear the defendant had completely misunderstood how eviction law worked.
First getting in because I had told him it was arranged.
All right. So but here's the problem. Okay, just so that we know. If I give you your judgment today for possession, right? And I'm just going to boil this down to the practicalities of it all. If I give you your judgment today, you can't do anything to move them out of the premises. You're going to have to file other paperwork to move them out of the premises, but you won't be able to do that until the 16th of January, right?
That's what I did the second time that you should have the second notice that I filed, because I filed twice now. What is it that,
Can anybody just please listen? to
yes,
me?
I'm trying to listen to what you're
All right.
asking me.
Let's say I find in your favor today,
Yes,
okay? And if I find in your favor today, they get 10 days to move out. Okay?
Yep.
But if they don't move on that date, then you have to file another piece of paper with the court for a writ of eviction. That has to get to me. I then have to sign it. Let's say that happens quickly, and let's say I even sign it that day. Then they're going to go to the sheriff's department, whoever has this particular area, to serve, the court officer to serve. Once it's served on them,
that's what I,
by
okay. I'm listening.
order, they're going to have 72 hours from the time it gets posted. So let's say everything happens as quickly as we possibly can. I'm now at January 22nd. Then you have to set a time. You have to get people to move them out.
Okay.
Let's say you got that all set up. You're probably going to be at January 25th, 26th.
Even after the constant interruptions and courtroom chaos, the judge still offered limited relief. Instead of allowing immediate enforcement, the court delayed execution of the writ until January 16th, giving the defendant extra time to move voluntarily during the middle of winter. The judge also ordered that escrow funds be returned to her after 15 days rather than awarded to the landlord.
I understand. I see what you're saying.
So, and by the way, it'll be January 25th, 26th, and you've had to spend money. Granted, you can get some of that money back from him, but you've had to spend money in aggravation to do everything.
I'm losing money. It wouldn't, Your Honor, is what you're saying, if we, instead of filing and you do this all today, that gives them till the 25th, and they, if they agree to go, will they go? I mean, I just want them to,
Go ahead.
excuse me.
I don't know.
Okay, well,
I
that's
have
what I'm
no
asking.
idea. It's part of what I have to do here. I issue orders, people don't follow them, then I enforce the orders.
Well, that'd be the second time they've told me they were going to and they didn't. So that's why I'm asking. I'm 3 months now behind. I mean, I live on the money that comes into there, pay for all the repairs and stuff I do and keeping up the place.
Okay, what do you want me to do?
Whatever is the quickest and the easiest way to, let's do it. If they'll be out,
What's the soonest? I heard what you told me. What's the soonest you guys can be out? I mean, even if you have to do sort of a temporary move to another, I mean, I know that's not ideal, but
Well, we were looking at, we would need the rest of this month. We would be out. That's what I was asking for.
I understand that. But I'm asking a different question. When's the soonest you can be out?
Well, 25th.
The hearing later shifted to another eviction dispute involving landlord Trudier and tenants Donald McMahon and his partner. Unlike the previous case, this dispute focused more on practical logistics than courtroom arguments. The tenants admitted they needed more time because their new property was still undergoing upgrades and repairs.
Given what I said, Miss Avey, will the 25th work?
yes.
See how easy that is? People just answer my questions. I've been doing this for a while. Some days like today, I'm thinking too long. Here's what I'm going to do. I'm going to grant a judgment finding no tribal issue after a hearing. I'm going to grant a judgment for possession. The writ date, that means the date they have to move, will be January 25th. 2020, 2024. Okay. Now, I'm just going to say to both of you, you can get yourselves out, just do it, because if more money has to be spent to evict, ultimately that's going to come back on you. And that, you don't want that. If everything operates quickly, then what's going to actually end up happening is the stuff that you have that you got to move, you might lose. I mean, if she gets in there and does it. So that's the best thing to do, is to just do that. I realize there's probably a lot of water that's passed under the bridge between the two of you. But if what can happen is, if it's just solely regarding this issue, that you can kind of talk to each other civilly about what needs to happen, it's a savings on both sides of this whole thing.
That's what
All
we
right.
tried to do. That's what I thought we did.
You know what, ma'am? I was just
I
talking.
know you're
and
tired. I don't
No, I'm not tired. I can do this all day and night
I'm just
long.
thinking all
But
the
as
money.
long as people stop interrupting me and listen.
I know. I apologize. I thought,
You need to submit a judgment to the court, and then I'll sign it. Any questions you guys have? Thank you very much. Everybody have a great evening.
Rather than escalating conflict, the judge carefully walked both sides through the actual eviction timeline and explained how long formal removal would realistically take anyway. After hearing both parties, the court negotiated a final move-out date of January 25th that both sides reluctantly accepted. The judge ended the hearing by encouraging cooperation and warning that further delays would only create more costs, stress, and potential property loss for everyone involved.